Leticia Olivia Hopper versus Crystal Jade Hopper, also known as Crystal Childers. Announcements, please.
Fred Hutter on behalf of plaintiff Leticia Hopper, appearing for Ryan Little.
Thank you.
William Copeland for Crystal Hopper.
Thank you. And we have the court-appointed receiver, Mr. Ben Williams.
Yes. Yes, ma'am.
Okay.
Yes, again.
All right.
Crystal Hopper should also be on the Zoom call, Your Honor.
Yes, I'm here.
Yes, I see somebody by the name of Crystal, Krystal.
Yes, ma'am, that's me.
The record will note Letty Hopper is also in attendance. Okay, so I called a status hearing to kind of get an update from Mr. Williams, a report kind of where we have been and where we're going. Mr. Williams, will you provide an update? I want to say at the last hearing, or maybe one of the last hearings, the sale of the property was approved. You provided notice of all of the terms, and that was going forward. And with a closing date, I think of October, early October, if I'm not mistaken. So why don't you take it from there, please?
Your Honor, first, thank you for your time today.
Oh, Mr.
I have
Williams.
actually wrote down there's really like 7 points I want.
Sorry to interrupt you. We're not catching everything you're saying, or at least I'm not on my end.
All right,
It might
I'm not
help.
sure
I
why.
hate to do this because typically, if you're present, then I'd like for you all to turn off on your cameras. Ms. Hopper, if you can do that. But in this instance, sometimes it also delays the audio. I don't know why, but sometimes it helps if you turn off your camera, Mr. Williams, and then let's see if the audio is better, but we're having issues.
Okay, does that work better?
So far, yes.
Okay. So I've prepared 7 points that I want to present to the court pertaining to repeated efforts by Miss Crystal Hopper to impede the progress despite clear direction from the court and the final judgment. The timeline here is critical as time is not on our side anymore. We have an October 16th closing date, and I believe the risk of this transaction is very real. The first point of order I wanted to bring to the court's attention was that it seems like the court order authority is being ignored, despite the court granting me the authority to proceed with the sale without Ms. Hopper's signature. She has continued to actively interfere with the sales process, including denying access to licensed professionals, misrepresenting facts to the city officials, and contacting outside parties with unfiled claims. The second issue I have is that the contractor's access has been denied on multiple occasions. Ms. Hopper's denied access to licensed and bonded contractors performing FHA required repairs. These delays forced the contractor to take another job, pushing back the repair timeline and now threatening our ability to close by October 16th.
Your Honor, we would object. This is all hearsay, and Mrs. Hopper will give testimony that she has not interfered at all. And anyhow, this is hearsay that Mr. Williams is giving, so we would object to this, Your Honor.
Okay, well, as the court-appointed receiver, I'm relying on him based on his powers under the court's final judgment in effectuating the sale. And so I need to hear kind of where things have gone. And as I understood it previously under the terms, the closing date was early October. And it sounds like from what he's saying, the closing date has moved from whether it was early October or some other date to now October 16th. And I need to understand why.
We hope that it does close, Your Honor. So, but that's our objection. He's giving hearsay, and the court will make its ruling. Okay,
Mr. Williams, you may continue.
So, despite knowing that the contractors were scheduled and vetted, Ms. Hopper's demanded licenses, background checks, and ultimately barred entry, which led to an emergency hearing, which we all know about. We've had the misuse of city inspections and false claims. Ms. Hopper misrepresented to the city of El Paso that we were doing unauthorized, unpermitted work that was being done. that resulted in a stop work order. However, the city's chief inspector has since confirmed in writing that the current FHA repairs do not fall up under the stop work order, which I forwarded that email to you and council. The order was for prior work Ms. Hopper had done before the sales process even began, and not for the current work for the FHA repairs. The fourth thing I had down here, she falsely accused the buyers of showing up to the property and harassing her, claims that were immediately denied in writing for both the buyer, and which appeared to be yet another effort to derail the
Your
sale.
Honor, again, we would object to this. This is hearsay. Mr. Williams says that the buyer showed up and that Crystal Hopper falsely claimed. All of that's hearsay. Mr. Williams was not there. And so we just ask the judge not to consider that testimony.
Your Honor, may I briefly respond?
You may.
My contention, Your Honor, would be that if Mr. Williams isn't permitted to discuss those facts, I'm happy to touch on them, and those would qualify as a statement of a party opponent. And so as such, they would not be hearsay.
Your Honor, that's true if they were made to somebody who was informing the court of what was said, but this is double hearsay. It's statements made to a prospective purchaser, which is being told to Ben Williams, which is being told to the court. If this was told to Ben Williams, then he can repeat what Crystal Hopper said as an admission of against interest. But anyhow, Mrs. Hopper will give her testimony as to people showing up at different times of night to look at the house. So
Your Honor, I'm sorry.
No, I had basically finished, and so we would just ask the judge to rule on our objection.
Your Honor, I would just add that the statements aren't being offered for the truth of the matter. They're only being offered to show stonewalling on the attempts to sell this house. That's all I have to say on that matter.
Okay, I understand the concern, Mr. Copeland, but I'm going to allow him to provide a complete update, at least so far that he's gotten out, but
Judge, would you consider me having a continuing or a running objection to this type of hearsay, so I don't have to object to every statement he makes that's told to him by a building inspector or by purchasers?
yes, and
Thank you.
I will note the running objection to hearsay, specifically any testimony of what others may have told Mr. Williams. I'm not going to test the veracity of that at this point, but I do want to understand, the delay.
Thank you, Your Honor.
Thank you. Mr. Williams?
Well, the accusations have deeply concerned with the buyers. They voiced that to me verbally and in writing, who are now worried about their safety and the reliability of the sale. The other point I had, Ms. Hopper seemed like she allowed the utilities to be shut off, some of the utilities to be shut off during the inspection, which resulted in a complicated inspection for the buyers to perform through the inspection. The other point is that Ms. Hopper has made herself unavailable during critical deadlines, submitted conflicting demands when we're negotiating, we're trying to finalize stuff, and has refused to cooperate with repair professionals, simply. And then last, in her email to me, that she said I was practicing deceptive trade practices are absolutely outrageous, baseless, and just false. I asked that the court, at this time, I respectfully asked the court to reaffirm my authority to complete the sale without further interference with Ms. Hopper, and order immediate completion of repairs to direct Ms. Hopper to not obstruct or in any way with the contractors or the appraisers, so we can get this done by October 16th. And I also recommend that the Ms. Hopper vacate the property immediately so that prevents any last-minute disruptions to possession and transfer of the title. The sale is fair at market value. I'm shocked and also surprised that the buyers are still willing to go forward, even though they're not getting some crazy deal. You know, it was praised at 310 and got a contract at 300,000, and they're still into it. I'm still I just think they really just want the house. But yeah, I just feel like it's been hard. It's been complicated to get this done. And I really feel it's just because she hasn't cooperated.
What was the original closing date, Mr. Williams?
The original closing date was September 23rd.
And then was there an amendment to push that?
Yes, we've had 2 amendments that would push it to October 16th.
The first amendment was to when?
The first amendment, I believe, was like October 6th, right around there. And then we extended another 10 days.
And originally there was the leaseback provision, right?
There was, excuse me, so I stand corrected. It was actually October 3rd, and it was a lease back. The lease back provision has been removed now.
And when was that supposed to end prior to the last amendment?
Well, the original contract said, okay, September 23rd, we would close. There was a lease back to October 3rd. That didn't happen. And then we removed the lease back, especially when we had the second closing date of October 6th. And then, of course, we have a different closing date of October 16th right now.
And are the repairs that are required by the lender completed as of today?
Here or not. We still have the shower door to be installed, the tub to be connected, and the paint on the outside to be finished.
When are the repairs expected to be complete?
If we were allowed back, we would be, it's hard to say. I think they're probably about 48 hours out from being done whenever we're allowed to get back in there to work.
And when is your understanding the contractors were forbidden from accessing the property?
It would have been Tuesday, September 30th, I believe.
That was their last day?
We sent them back over there and they were denied access.
By whom?
It was told to me by Miss Hopper.
Okay, so they haven't been there since September 30th.
I believe that is correct.
And from your
You know-
perspective, is everything set to proceed with closing other than the repairs that you just listed?
Well, it would be a final inspection from the appraiser to make sure the FHA required repairs are sufficient. And then from there, it's just a logistical process from with title and the lender and things of that nature. Yes, that's the last process to this whole thing.
Okay. Mr. Copeland, you wanted to say something?
Yes, Your Honor, there was a stop order issued by the City Inspection and Planning Department. Mr. Williams says that's now been lifted, and that was on October the 2nd, 2025. So we're glad that that's been lifted and that there's no impediment. I would just have when the court is ready to have Ms. Hopper give a little testimony.
Okay, Mr. Hutter?
Yes, Your Honor. There are 2 additional issues I'd like to raise with the court before Ms. Hopper's testimony. First, the court should be aware that Miss Crystal Hopper filed to probate her mother's insolvent estate. That's case number 2025 CPR 0112, filed in probate court number 1. It's our position that this filing was conducted to harass my client and cause us to incur needless attorney's fees. The only asset of the estate was the partitioned home. And that was distributed by Lady Bird Deed prior to Miss Teresa Hopper's death, their mother. My client is paying her legal fees out of pocket. And so because of all the status hearings that we've had since the court signed the judgment in this case, and after this partition, my client's incurred about $6,500 in legal fees. And that's before today's hearing due to our required intervention. Now, next, I'd like to discuss an extortion attempt, or what appears to be an extortion attempt on Mount Screen Myers. Mr. Little forwarded the emails in question to the court back on September 26th, but I'll provide Your Honor a timeline. On September 15th, the president of our law firm, Clyde Pine, he received an email from someone purporting to be William Wallace, from an email address, good-versus-evil2025@outlook.com, and that's versus with a VS. The email chain, the entire email chain was provided to the court by Mr. Little. The individual alleging to be William Wallace claimed to represent some anonymous party and vaguely alluded to...
We object. Any matters outside of the partition are not proper for today's hearing, or are not proper before this court. If they believe that they have suffered an extortion attempt, and they can report it to the proper lawful authorities.
Your Honor, if I may...
We would object to any more of this conversation or testimony, Your Honor.
Your Honor, if I may be allowed to get to the point, it is our position that this extortion attempt actually goes to the heart of this partition. But I would need to continue to get to that detail.
Why don't you just jump there?
I'll jump there, Your Honor. So bottom line is, after analyzing the emails and figuring everything out, we've concluded, and as evident in the emails, it appears that Ms. Hopper sent these emails to Mr. Pine attempting to extort $60,000 from our law firm, in addition to attempting to have Ryan Little cease representation of Miss Letty Hopper in this case, and in an attempt to have some other attorney from our law firm begin to represent Crystal Hopper. And this is evident after comparing the email addresses on the emails, this William Wallace address, with the fact that Miss Crystal Hopper actually signed her name to the bottom of one of those emails, identifying herself as this mystery person attempting to extort our law firm. And so it's our contention that in addition to trying to get $60,000 from our law firm, she was apparently attempting to have Mr. Little drop this case and then have our firm assume representation of Miss Crystal Hopper. And so what we're asking the court to do, Your Honor, is one, order that the repairs be permitted to occur without any delay, the FHA-related repairs. Two, that the court issue a writ of possession. We would ask that Crystal Hopper be required to vacate within 3 days of today's date, given all of these events. We would ask for an award in the amount of our attorney's fees of $6,500, or alternatively, that the court award that in the form of sanctions.
Mr. Copeland?
Yes, Your Honor, that's all hearsay. Mr. Hunter does not have knowledge of any of those facts. And assuming what he says is true, that Crystal Hopper communicated with his law firm, a principal can always communicate with the other lawyer on the other side. The other lawyer can say, you have a lawyer, I'm not going to communicate with you. But the principal can always communicate with the lawyer on the other side. And if a person believes that there's been a fraud committed against them, they have a right to communicate that to anyone they want to. As far as a probate, should I pass away one day, I will. All of humanity will, unless we're raptured. My children have a right to probate my estate. Well, the guy across the street may say William Copeland doesn't have any assets. That's to be determined. There may be a bank account in Las Cruces nobody knew about. So it's perfectly reasonable for one daughter to probate her mother's estate. I would not think that there would be any basis in law for a judge to order anyone not to probate their mother's estate. The property to this home, subject to the partition action, Your Honor, passed at the moment of death by a ladybird deed. Now Texas uses Texas revocable transfer on death deeds, TODs, but our courts are accepting the ladybird deed. So the moment her mother died, the home passed to the two daughters, independent of the estate. Texas law even says it's not part of the estate. It passed independent of the estate by the deed. We don't look at the will. There was a will, there was no will, there were 10 wills. This home passed by the deed. And so anything about the probate, or they want $6,500, or Mrs. Hopper has sent them some emails suggesting that perhaps there has been some fraud committed, that's not subject to us paying attorney's fees for asserting our rights, Your Honor. And Mrs. Hopper has been cooperating. She's raised a few facts in times past, and you've already awarded about $25,000 in lawyer's fees. That people were coming at odd hours of the night, but she's cooperated since the judges since this court issued its judgment, and I would have her give testimony to that effect. It's set for a closing on the 16th. There's 2 days worth of work to be done, very minor, a shower door, some painting, a few other things, and this sale will go through. So we would ask that you not evict Mrs. Hopper from her homestead. I don't even know if the court has the authority. I understand that the court has ordered a partition, but until such time as the home is sold, this is Mrs. Hopper's homestead, and that's almost inviolate under Texas law. So we would ask that the court deny any $6,500 in attorney's fees, and I think it just kind of mucks up things, saying that we're trying to probate an insolvent estate. We presume that her mother had a bank account with some money in it when she died, so it's not insolvent. She had some furniture in the home in which she was living, so it's not an insolvent estate. There were assets. We don't know the extent. We don't know if there wasn't $100,000 taken out of the account after the mother died. We don't know. And so we have a legal right to probate the mother's estate.
Mr. Hutter?
Yes, Your Honor. First, with regard to the extortion attempt, again, we're not arguing that Ms. Hopper cannot reach out directly to our firm. It is the circumstances and the manner in which she reached out using an alias. And for all the details, Your Honor can see the emails for herself establishing what I've just said. And so it is the manner in which she reached out, and again, seeking $60,000 and that our firm represent her, that is at issue here, and that is indicative of someone who's trying to stonewall the sale of this home. With regard to the partition, Your Honor, again, it's our position that the house is the only asset that is subject to a sale, and that is what we are trying to resolve here today, and that this proceeding is all that should be required to satisfy really the only thing that needs to be done in this matter, which is the sale of this house and the satisfaction of that. With regard to the $6,500 in legal fees, Your Honor, that does not account for the partition. That accounts for the legal fees expended in this matter for the status and emergency hearings following the court's signing of the judgment in this case. That is what that is for. The $6,500 doesn't apply to the partition. It's only to this matter and our ongoing representation in this matter. And so with that clarification, Your Honor, I'd be happy to ask Mr. Little to file evidence of his attorney's fees to that effect. But if you have any other questions, I'd be happy to answer them.
Mr. Copeland, do you know how the city of El Paso got involved?
I do not. I assume that Mrs. Hopper believed that she would be exposed as an owner selling a house if the repairs were not properly done, that a buyer could come back and sue her. So I do not know, but I believe in that. That's subject to Mrs. Hopper giving us the answer. If she legitimately called a city department and asked that they make sure that proper permits were taken out, which is a reasonable thing to do when an owner is liable if they sell a house to a buyer and there are either patent or latent defects or any other matters that would have. Sometimes they will tell you to tear down a whole addition if permits were not taken out. So I assume Mrs. Hopper did, but that would be up to her to give testimony.
And why would testimony be needed by the parties in this situation?
Because everything's hearsay, Judge. I'm not there. And Your Honor, if Mr. Little has any attorney's fees, well, I've been to every hearing also. And so I would be entitled to my attorney's fees. I think the court has basically determined attorney's fees, and that each party, I believe, should compensate their own attorney's fees forward. So we would just ask the court to allow Mrs. Hopper to stay in the house until the sale, that there be no attorney's fees awarded, that the court discount all of this extortion testimony. If Ms. Hopper believes she's owed $60,000, she can certainly say that to anybody she wants to. And she can certainly probate her mother's estate and determine what assets there are.
With respect to the probate issue, that's really outside this court's jurisdiction. I understand, Mr. Hutter, your frustration, but whether or not the house is the main or only asset, that's really not a determination that I can make with respect to the probate of their mother's estate. So I understand your position. I understand Mr. Copeland's position, but I'm going to have to agree with him that I don't have any jurisdiction. There's nothing that I can do. I certainly can't order that proceeding not go forward. I think there might be some overlap. There may need to be discussion in that probate proceeding about, this lawsuit. But that's certainly not within the jurisdiction of the claims that were asserted in the underlying case and kind of where we are now in the sale of the property. With respect to the verbal request for fees, I'm going to take that under advisement. I know there's been this verbal request at today's hearing. There may have been a verbal request at prior hearings, post-judgment as well. To the extent that there are any requests for fees, I think you all just need to file motions with your fees, explanation of the fees that are alleged to have been reasonable and necessary. And then we can take that up once the net proceeds are in the registry of the court.
Thank you, Your Honor.
So
Understood, Your Honor.
Yes. Did somebody?
No, I'm sorry. I said understood, Your Honor.
Oh, okay. I thought somebody was trying to say something else. Time is of the essence on this sale. And for the October 16th closing date, to be realistic, I have allowed Miss Crystal Hopper to remain in possession of the property, understanding that she's a co-owner. We've handled the partition matter and the claims for reimbursements and offsets and other claims. But really at this point, I'm going to order that she vacate the premises and that Mr. Williams has full possession of the property. So anyone who is residing in the real property needs to vacate by 5 p.m. on Monday, October 13th. Any keys or garage openers or any other locks and keys need to be left on the kitchen counter so that Mr. Williams can take over full possession of the property. while Miss Crystal Hopper remains in the property up until October 13th, if she so chooses, she must give full access to the contractor performing the required repairs. And that means that the contractor should have access, unfettered access, through the front of the house, through the back of the house, through any other means that are reasonable between the hours of 8 a.m. and 5 p.m. every day, not just during the business week, but also on the weekends. If anyone is still residing in the premises by 5 p.m. on October 13th, a writ of possession shall issue immediately thereafter. Anything else, Mr. Williams? Oh, one more thing. So that the sale, that is my order so that the sale can go forward on October 16th. After the sale of the property, Mr. Williams, if you will provide a report of the sale by filing that of record.
Yes, Your Honor.
And all of the net proceeds except for the 3% commission payable to Mr. Williams shall be deposited by the title company into the registry of the court, where those net proceeds will be held until further order of the court.
Your Honor, just a correction. It's a total of 6% for both sides of the deal.
I'm sorry, yes. So 3% for you and then a separate 3% for
Yep.
the other agent.
Yes.
Additionally, Mr. Williams, you are authorized. I know that I had authorized the sale under the terms that you provided previously. And the only thing that has changed, as I understand it, is the closing date and the leaseback provision has been left out from the original contract. But you, the sale has been approved and confirmed, and so you have the authority to proceed at closing without anyone's signatures as the court-appointed receiver who has full access and possession of the property, so that you don't need any other signature or document other than maybe the court's order reflecting my rulings today to provide to the title company.
Thank you, Your Honor.
Mr. Hutter, will you please prepare an order to this effect?
Yes, Your Honor.
And if you'll circulate that to Mr. Copeland just to give him notice, but I'd like to get that order entered as soon as possible. But everyone is here, all of the parties are here, all counsel are here. I know Mr. Little isn't here, as I understand it, he was in trial, and so that's the reason for your appearance, Mr. Hutter. So are there any questions at this point? Mr. Copeland?
Your Honor, you've directed that she vacate the home by Monday, October the 15th. That only gives her 2 working days to find another place to live. Normally, a person does not vacate until the date of sale, which is the 16th, because then the purchasers are the new owners and they have a right to begin living in the house. So while Mrs. Hopper will not be happy with any order to vacate, we would ask that it be extended until Wednesday the 15th at 5 o'clock, and then she would be out on before the day of the sale. You've already directed that she cooperate, as she's been doing, with the contractors to finish up the last no more than 2 days worth of work. Mr. Williams phrased it as 48 hours, which is 224. So in 2 days, this work can be done. So we would ask that she be allowed to stay in until Wednesday. So she has 4 working days to procure another place in which to live.
So based on the original contract, and that was kind of the reason that I asked Mr. Williams about the leaseback provision. Did I write that down? And that was to end October 3rd. So knowing that this sale is imminent, that it was the end of September, then it got moved to early October, and now October 16th, it cannot move anymore. This sale has to be completed. I would expect her to have prepared for this move, for her to vacate. So for that reason, in addition to the fact that even not relying on hearsay, we've had multiple hearings about whether or not the repairs can proceed, whether or not the sale can be approved, and rightfully so, at least for the sale. All the parties need to know the terms and express any dissatisfaction or opposition to that. But it's been more than one hearing where I do know, and I don't believe that Crystal Hopper has understood the court's directives. Because I don't
May I say anything?
No, unfortunately you can't. You have an attorney
Okay.
and he has done a really good job voicing his position on your behalf. There's really no need for testimony at this point. So because of that, she has 4 days to get her affairs in order so that she can vacate by 5 p.m. and any other residents that are, any other individuals who are residing at that property. The repairs have to get done. And if they're not going to get done while she's there, which they should, because I've ordered her to allow those repairs to be done. But if they don't, then there's still that period of time from when she vacates so that they can get done before closing, so that the buyers can have the repairs inspected prior to closing. I wish I can give more time, but unfortunately we have delayed and delayed and delayed. And I know not one single person is to blame. It's kind of the circumstances of the sale and getting repairs done and contractors involved. But we cannot waste any more time. Otherwise, I'm afraid that the sale won't go forward if it doesn't close when it's intended to close on October 16th. So the request for additional time is denied. Anything else, Mr. Copeland?
No, Your Honor.
Mr. Hutter?
No, Your Honor.
Okay, then I will be on the lookout for an order, hopefully tomorrow.
I anticipate so, Your Honor.
Okay, wonderful. Anything else, Mr. Williams? I'm sorry.
No, Your Honor.
Okay, thank you all very much. We're adjourned.
Thank you, Your
you.
Honor.
Thank you.